take just a minute, but we'll call the second case on today's docket, which is case number 127123 from a decision of the Workers' Compensation Board, Linda S. Henretty versus Kansas Workers' Compensation Fund and others. Would the parties please come forward? Would the parties state their appearances? Sorry, just as you guys sat down. Would you state your appearances?
Oh,
Yeah.
excuse me, Your Honor. John Nodgard on behalf of the Kansas Workers' Compensation Fund.
Thank you.
David Ferris.
I'm Jordan Massey.
We're here on behalf of the claimant appellee, President.
Thank you. And who will be arguing?
I will.
Right. Counsel, would you like any time for rebuttal?
2 minutes.
2 minutes are granted and you may begin.
Please, the court and counsel, this is a workers' compensation case, but basically it's not a workers' compensation case. The facts in this case are all stipulated to. There are no issues about any facts whatsoever. The question is, does Kansas have jurisdiction to award benefits under the Kansas workers' compensation laws? We raised two issues, which I'm sure you're aware of. The first one is a contracts case. In this particular case, the claimant entered into a contract in the state of Kansas. We don't deny that. Our position is that within that contract was an implied condition precedent that required her to move to the state of Montana. Had she not moved to the state of Montana, you wouldn't have an employment contract. The Workers' Compensation Appeals Board, in its decision, addressed the issue about the ministerial duties that had to take place once she relocated to the state of Montana. That's not the issue. I understand the case law in this state says ministerial duties to complete a contract does not prevent the contract from being formed in the state of Kansas. What I'm arguing is that you had a conditional contract subject to the precedent that she moved to the state of Montana. Once she moved to the state of Montana, which was an act that she had complete control over, then the contract became a legally enforceable contract. We throw the term in the comp arena about a contract, but in this case, it's a conditional contract, not a legally enforceable contract. Had she never moved to the state of Montana, there would not have been a legally enforceable contract. In this case, the promisor says, the employer in the state of Montana, I will pay you if you will come to the state of Montana and work.
And they did pay her $5,000.
That's true, but if she didn't move to the state of Montana, she would have had an obligation to refund the $5,000. So
Does that mean it's not a contract then?
it's a conditional contract. The last act to make that contract a legally enforceable contract.
It wasn't binding then until she moved? Is that your position?
That's my position.
So that hospital couldn't have sued her if she didn't come out there because they had no contract?
It was a conditional contract that required her to move to the state of Montana.
Sent her $5,000.
Correct.
She went ahead and moved. And why isn't that completed? Why isn't that a completed contract?
Because it was conditioned upon her making the move.
Well, she did move and she got her.
And once she,
But the contract was completed in Kansas, was it not? And that's your position.
No, my position is the last act to complete the contract was her changing residency to the state of Montana.
So it's not a contract. You have a question of fact that you're arguing that, and that is this condition precedent wasn't met. So you're actually making a factual argument, aren't you, counsel?
No, sir. The contract had the implied condition precedent that she had to move to the state of Montana.
How did our learned workers' comp appeals board rule on this issue?
They ruled that the ministerial duties that she had to complete in the state of Montana were not relevant as far as a contract being formed in the state of Kansas.
And by that, they meant what? The W-2 form and all of that
Yes.
sort of thing?
Yes, yes,
All of the paperwork that we do in modern employment?
correct. And I'm not arguing that. I mean, there's plenty of case law in the state of Kansas that says that those ministerial duties are not the last act to be an enforceable contract. I'm arguing the last act required the permanent change of residency.
And now-
Once she did that,
Now,
the contract
now
was
you're
enforced.
rewriting it. It doesn't say permanent change of residency. You were saying they moved to Montana. She could have moved. Is your argument that she had to move or she had to change her residence?
Well, my argument is that she had to move and become a resident of the state of Montana in order to go to work up there.
Is that what the contract said?
It's implied in the contract. If she hadn't been to Montana, she couldn't report to work. And I'm not arguing about it. There are cases where there's temporary employment, where there's a contract in the state of Kansas, somebody temporarily goes to another state for work and
Does that
then,
apply
and then
here?
comes back to Kansas. No, because in this case, she had to permanently move. It wasn't a temporary position. It was a permanent position requiring her to relocate to the state of Montana.
Counsel, I want to piggyback on something that Judge Hill asked, and that is, let's say hypothetically that she just didn't go to Montana, right? And maybe, whether she accepted the $5,000 or not, she just didn't go to Montana. Does the hospital up there have any recourse? Do they have any right to sue her for, say, specific for performance to come to Montana, or for breach of contract for not coming to Montana?
Well, it's an employment contract, so you can't have specific performance for someone to perform an employment with someone. They would probably have a right to file a case in the state of Montana to get a refund of the $5,000.
Why?
Because they advanced her on the condition that she come to the state of Montana. If she didn't go to the state of Montana,
It
then
sounds to me like you're arguing that there was an enforceable contract about everything except one thing. So there was an enforceable contract for the most part, but there wasn't an enforceable contract for purposes of determining where that contract was made.
I'm saying there was a conditional contract with a condition precedent that she had to move to Montana. Once she moved to Montana, then you have a legally enforceable contract. And that move was the last act to make the contract legally enforceable.
And what law would apply? Had she not moved, what law? Would it be Kansas law or would it have been Montana law?
You know, that's a good question, because that gets into my second argument.
It certainly does, and
this
that's why
case,
I asked.
And this full faith and credit and the due process, which I would like to address.
Well, answer my question first.
I think I think Montana, if they were the plaintiff, the employer in Montana could have filed an action in Montana to seek refund of the $5,000 that they advanced, and Montana law would apply.
Contract was signed in Kansas, it was delivered in Kansas, and the cash money was handed in Kansas. She signed it here and sent it back. She did everything that she was required to do under that paper.
Except move. She had to relocate.
So you would say Montana law would apply?
This is a case where the Montana law would apply if the suit was brought in Montana. If they chose to bring the suit in the state of Kansas, then the state of Kansas law would apply.
I see.
So you have a dual jurisdiction here, which is where we're going on the next step that I raised on the constitutional issues about the full faith and credit.
Now, you didn't bring that up before.
That is correct.
Why should we consider it?
Because that is an issue which would be determinative in this case, since all the facts are stipulated to.
If all the facts are stipulated to, why did you ask for us to remand it for a hearing?
Well, I asked either this court could decide or remand it for further consideration. I think this court can go ahead and make the ruling under State versus Herbal, since the questions of law arising on proved or admitted facts would be finally determinative of this case.
Well, we know that there were no facts presented on this issue to, you agree with that, don't you? To the Board of Appeals or
On
to
the
the ALJ
on the contract issue?
on this constitutional issue.
Well, the constitutional issue is that should Kansas apply Kansas law to this case, or should Kansas apply Montana law to this case?
Was it argued, this question argued to the ALJ?
No, that issue, no.
Was it argued to the Board of
No.
Appeal review?
No.
So you're bringing it up for the first time to us, and you ask us to remand it. But you're also saying we could hear it because it's all settled.
That's correct. This court
It's a question of
can
law.
go ahead and hear it, or you could remand it and ask the board to reconsider that.
You don't find that conflicting?
No,
Saying we can send it back for more fact finding
not.
and we can do it?
Well, it's not fact finding. It's for the interpretation of the law, which is why I think this court can go ahead and hear it.
Counsel, can you help me understand the constitutional question you have? Because a choice of law question is not a constitutional issue. Should Kansas law or should Montana law apply? So what is the constitutional question that you're raising?
I outlined it in the brief. There's a whole series of United States Supreme Court cases that are cited in the brief that say that a forum state, when in this case where the case is brought in Kansas, the forum state does not have to apply its law. It can defer to the state where the action was.
But under full
fine.
faith and credit, that's not really the analysis. The analysis is whether Kansas is compelled under some instances to only recognize what's happened in another state or the law of another state. And so would the Kansas Workers' Compensation Board, assuming that the Kansas Workers' Compensation Board has jurisdiction, would the Kansas Workers' Compensation Board even have the ability to apply Montana law?
You get into this issue about one state cannot enforce its laws to be applied in another state. Otherwise, you'd have Kansas saying, Montana, you have to apply our laws because the contract was made here. Montana saying, no, Kansas, you need to apply our laws because the injury occurred here. And the Supreme Court, U.S. Supreme Court cases basically say
That as long as there is some connection to the local state, then that doesn't violate full faith and credit.
they don't exactly say that. They say full faith and credit generally applies to courts of general jurisdiction, not administrative proceedings. Administrative proceedings are creatures of statute created by each state. So the United States Supreme Court has said that in a series of cases, each state should look at the criteria about where was the injured employee employed, where was the employer employed.
Is that analysis, so that was the analysis under Alaska Packers and Pacific Employers, but under Allstate versus Hague and Phillips Petroleum versus Schutz, it seems like we're just looking for some kind of minimal connection. Is that not the case?
I don't think it's a minimal connection. I think they have to have some kind of substantial connection with the case. And what I'm saying here is Kansas may have had a connection at the time that this contract was entered into and she moved to Montana. But after 9 years, when the injury occurred, 9 years later after she made the move, she applied to Montana for benefits. She was awarded benefits in Montana. She returned to work for the employer in Montana. And then basically about 13 years later, she comes back to Kansas and files the case here. Based on those facts, I don't think Kansas had a substantial enough connection with this injury to allow it to apply Kansas law, and that they should have deferred to the case and the proceedings in Montana. And that's really the issue. I think this court can.
Argue that before the ALJ?
No, this constitutional issue I'm raising for the first time on appeal,
But
which
you can argue equitable things to the ALJ. I've seen it any number of times. And actually, you're saying it's an equitable thing, isn't it?
no, there's case law out there that says, in fact, it's, I can't remember I think it's Thomas versus Potomac Electric, but basically says both states have authority or has jurisdiction over the case. And technically, you could bring a workers' compensation case in one state, get your benefits, and then, like in this case, come to another state and get additional benefits. And the United States Supreme Court has previously said that you can do that if each state has a substantial connection to the case. And when they ruled on that, it was an employee whose company was in the District of Columbia. He was hired in the District of Columbia and was sent over to Virginia to do some work over there and was injured. He filed a case in Virginia. Virginia gave him benefits, and then he came back to the District of Columbia, filed another case in the District of Columbia, and obtained benefits. United States Supreme Court says you can do that.
So how, doesn't that cut against exactly your argument?
Well, in that case, both states had a substantial connection to the case. Virginia, because he was working there, the injury occurred in Virginia. The insurance carrier was in Virginia. In the DC circuit, the employer was in DC. The claimant was a resident of DC. There's no Kansas cases on this. These cases are rare. That's why this is kind of an interesting case to be before this court. But I think the issue is the court needs to examine and see, did Kansas have a substantial enough connection after 13 years to award benefits under the Kansas Workers' Compensation Law?
I don't see why you couldn't have brought that up in front of the ALJ and then later the board. That particular issue right there.
It could have been, and frankly, I'll just tell you what happened. I was focused on this issue on the contract. I also focused on the question about equitable estoppel, which does not apply. And it wasn't until I was writing this brief that I ran across a case that started talking about full faith and credit. And I said, wait a minute, maybe that's the underlying issue here. And so I raise it for the first time based on those facts, and under State versus Herbal, I think this court, I'm entitled to raise that issue, and this court can address it. So, in conclusion, I would like to see this court write an opinion, go through the steps that are required to see whether or not Kansas had substantial connection with this case in order to apply the Kansas workers' compensation laws. I think that's what needs to be done. The Workers' Compensation Fund's position is there is not a substantial enough connection, and therefore the board should not award benefits to be paid by the Workers' Compensation Fund, which essentially had no connection whatsoever with this case. Everything took place out in the state of Montana.
Thank you, counsel. We've had many questions for you, so you still have your 2 minutes for rebuttal. Counsel? Counsel, we went a little long, and so I'm going to give you a little bit of leeway if we need it.
Thank you.
But that doesn't mean you have to use it.
May it please the court, I'm going to have to disagree with opposing counsel. The first statement he mentioned, this is a simple, easy work comp case, plain and simple. These dual jurisdiction cases they happen all the time. I probably have 10 or 12 going right now in my practice. And these statutes, KSA 44506, have similar, or other states, most states in the union have a similar statute to protect their citizens who enact or contract to perform work outside of the state, where they may be heard outside the state, inside the state. And so it's quite common for states to enact these statutes to protect their citizens. And in this particular case, the only reason we're here is the insurance company for the state of Montana refused to participate all the way through the process. So that brings the Kansas Workers' Compensation Fund in, and then there is a statutory provision for the fund to get their money back from that insurance company in KSA 44532A.
Well, let's get to the point.
Okay.
The fund argues that your client needed to fulfill a condition precedent
Yep.
In order to have a valid contract. What's your position on that?
Absolutely not. There's nothing in the contract itself that you mentioned earlier, Your Honor, that indicates so. And frankly, if you look at the two administrative law judge decisions and the two board decisions, they agree. There's a litany of cases in Kansas workers' compensation where a contract is fully formed, even with just a quick phone call, which isn't even recorded. That's a contract. And for them to then go get a drug test. There's cases where they go out of state to pass a driving test. There are cases where they go out of state to fill out some paperwork and come back.
Well, I'm not interested in those. I'm interested in this one.
All right.
When was the contract completed?
The day it was signed as an employment contract
In Wichita?
and sent back from Wichita, Kansas. And the fax even has the Wichita phone number on it. It was enacted at that time, and that's what all the lower courts have decided in this case.
When did she get the money?
Got the money, I believe, within a week thereafter,
While she was still in Wichita.
while she was still in Wichita. So if you look quickly at the facts, she applies for the job. She gets a phone call expressing interest. They fly her out there to meet everybody. They make an offer by phone and say, you're getting an employment contract by fax, sign it and send it back. She got the contract, signed it, faxed it back, got the $5,000, resigned her position at Wesley that she'd had for 9 years, sold her home, moved to Montana. And at that time, if you look at the affidavit completed by the HR director of the hospital, which was an exhibit presented by opposing counsel, it says she had to fill out the paperwork to commence working, not to finish an employment contract, to commence work on that date, which was simply, again, to quote the board, merely a formality or a condition subsequent. And that's just the W-2 and.
So your view of the move to Montana was a condition subsequent?
Subsequent. There is nothing in that contract that indicates, now, obviously it's implied that she's going to move to Montana, but there's nothing in that contract, nothing that indicates that the contract would not be completed until such time as she arrived. And the board goes into great detail. Why would this woman completely change her life if she did not feel she had a job already done and signed, sealed, and delivered before she arrived there?
So that contract was completed in Kansas. What law applies?
KSA 44506. And it makes it very clear that for an out-of-state injury, Kansas is proper jurisdiction if the contract of employment was made within the state.
Actually, I was referring to what laws should govern us as we interpret this contract.
Kansas
Should we
law.
apply Montana law or Kansas law?
Kansas law.
And that's because it was completed in Kansas?
Correct, Your Honor.
There was some wording in that fax I wanted to, go ahead with your.
Thank you. So think about this from her perspective. What if she would have gotten out there and some paperwork couldn't have been completed correctly? Or it took longer, or they decided, hey, this position is filled, we're moving you to a different position. And we have to look at this, and I think that the questions that you raised earlier are good ones. Or if she didn't show, can they then recover the monies they spent and bring her out there? And my answer would be yes, because a contract had already been executed between the parties. So this decision has been clear 2 times at the ALJ and 2 times at the board. And I think the statute is very clear and unambiguous. If the contract was made within the state, then Kansas applies. Kansas law applies or can apply. These dual jurisdiction cases can go either way. And that's,
Let me ask, let's assume that Kansas law applies and the board has jurisdiction. If that's the case, is there ever a circumstance when an ALJ working for the Workers' Compensation Board or the board itself could apply a law other than Kansas?
no, I'm unaware of that ever happening, and I'm unaware of any case law to that. I mean, we're within the and you know, the Kansas Workers' Compensation Act is an exclusive remedy in this state, which was briefed in my brief.
Yeah, I've got the portion I wanted to ask you about.
Yes, sir.
This letter of position, and I'm referring to, I think this is the ALJ's ruling. This letter of position offering does not constitute a contract of employment for any specified period of time. What do you take that to mean?
That in going out there wasn't a specified period of time that would then make that contract valid. The contract was valid even if she's there for a day. That's what I take that to mean.
They're not offering her a position for life.
Correct.
They're not offering her a position for a year.
Correct. So she's taking this at her own potentially peril, that ultimately she could be out there and it didn't work out and she's out. I mean, I find it hard to believe that any reasonable person would go through the steps that she went through if she did not truly believe she had an employment contract at that time. And why would they send $5,000 to a woman that they didn't fully believe was coming out there to work under a contract already executed?
I want to turn back to the jurisdiction of the board and then what the board could hear or could not hear. So we've decided that or at least it's your position that the board couldn't apply any law other than Kansas. Could the board decide a constitutional question?
I do not believe they can, but they will mention that it's brought up and defer to a higher court if it goes there.
What's the point of having us go through that rigmarole of having it be brought up if it can never be answered?
Good question. And I think you've answered it. So from our perspective, they need to be brought up at the lower level because that's what's required. But from a practical standpoint, since they can't hear constitutional issues, I understand. And I can't argue with the logic in the arguments made by opposing counsel about that particular issue. Really quickly, I just wanted to talk about the subsequent issue brought up by opposing counsel. This is a new one for me, and it's obviously why we're here. But there is nothing in the statute which is clear and unambiguous that indicates that Kansas has to have any substantial interest in this matter. It's clear that as long as the contract was formed here, Kansas law can apply, period. So to put a burden on the claimant to show that there is some type of an interest here is an unfair burden. It doesn't happen in any other dual jurisdiction case. I've never had one go this far or have this argument brought up. But when a statute is clear and unambiguous, it must be followed. And
unless it violates the Constitution.
Unless it violates the Constitution. But if you think about this, and this is in my brief, KSA 44506 has been here since 1923. There have been massive sweeping changes in the work comp law, including a huge change that just went into effect July 1 of 2024, and it's never been touched. If the legislator didn't intend for this to protect its citizens, it'd be changed. If there's a hierarchy, okay, there must be a special, or there must be some nexus between the state and the employment or the contract or the claimant. It would be in the statute. There's not. And so these dual jurisdiction statutes allow an injured worker of a state to assist them in selecting their forum at a place that's convenient to them. I would argue my client is now in Kansas, has been for years, and has hardware in her leg. And if in fact she requires additional medical treatment, it will be done in Kansas. To me, I mean, if you're requiring that of me, which I don't think is necessarily part of the statute, that would be my argument to the nexus between the state and my client in the state's interest in this particular workers' compensation claim.
But the jurisdiction arises not because your client is presently here, but because the contract was
Started then,
completed.
correct.
All right.
Yes, Your Honor. Yeah. And again, we cited in our brief just a plethora of cases, very similar fact patterns, but a phone call is enough. And these condition precedents that are brought up have been routinely turned down by higher courts all the way up to the Court of Appeals, and that particular case was cited in our brief. I'm here to answer any further questions.
Further questions from the panel?
Thank you very much.
Counsel, you have 2 minutes, but I will say you don't have to use it either.
I cited 2 cases in our brief, Sweet versus Stormont Vale and Barber Oil versus Patrick, defining a condition precedent. It says a condition precedent is something that is agreed must happen or be performed before a right can accrue to enforce the main contract. It is one without the performance of which the contract, although in form executed and delivered by the parties, cannot be enforced. And what I've argued on this condition precedent, requiring her to move to Montana, you had the contract, but the final act to make that contract enforceable was her move to Montana. At that point, and that was the last act, so therefore the contract was formed in the state of Montana.
Can you point out any language in the contract that says she has to move to Montana?
No. It's
There's no express provision in the contract that says you must move to Montana.
That's correct. But had she not had to move, she couldn't be employed.
She was required to work.
She had to
She
move.
wasn't required to move.
She, well,
Was she? She was required to work.
if she
She
does,
could have maintained her residence here, just had a temporary domicile out in Montana. Right?
the issue is she permanently left the state of Kansas and moved to Montana and changed her residence.
No, the issue is the contract,
Okay.
not what she did, but what was the contract and whether it was a contract was the last act was done in Kansas. That's the issue, right? That's your whole case is on that.
The first part of the case,
Well, I understand.
okay, is
You've got the later
on that
issue.
issue. So, I mean, the whole question is, what was the last act to form the contract? I mean, we all agree.
Is the question about the condition precedent though, because it's not expressly identified within the contract, it's something that's extra. Isn't that a factual question? That there would need to be facts found to say that the parties understood that there was this condition precedent that she moved to Montana, and we don't have any findings like that, do we?
No, there's no findings of the fact because we stipulated to all the facts in the case. The second issue then again is if this court does find there's jurisdiction, then the issue is, should Kansas apply its law and award benefits, or should it defer to the proceedings that took place out in the state of Montana? Because Kansas does not have a substantial enough contact with the employer, the employee, the accident, the supervision of that employee. This was 9 years later. So,
Counsel, I've given you a little bit more time, but I'll give you 30 seconds to wrap up.
well, so I mean, I think that's the second issue that this court needs to look at. And that's the due process constitutional issue. I mean, I'm here representing the Workers' Compensation Fund, who's now right now is required to pay benefits for something for which they had no contact whatsoever. And frankly, I know counsel raised it. I don't think we have any recourse. We can't really, I don't think, sue the employer or the Montana State Fund out there in the state of Kansas because I don't think there's sufficient enough contacts with the state of Kansas. And frankly, the attorney out in Montana has told me so, as such, that they would fight that. So my client is, without really having much to say in this case, has been awarded and in order to pay.
Thank you, counsel.
Thank you.
Thank you to everyone for your interesting arguments in this case. We'll take the matter under advisement